Recently, I was talking with a guy who was installing my garage door, and he mentioned how at one point, he used to conceal carry because he was afraid of being robbed. And he also mentioned that he no longer does so. He no longer carries because he's afraid of what, some district attorney in his county would do if he had to act in self defense. So I thought I should look into self defense law here in North Carolina. Now, we're all familiar with Florida and its stand your ground law. But what about here in North Carolina? In the state of North Carolina, the right to defend yourself is written into law. But did you know that certain laws not only justify your use of force, they could also make you immune from ever being prosecuted? Today, we're going to dive deep into North Carolina's self defense immunity statutes, and we're going to talk about how they work, what they can mean if you're ever forced to use defensive force in your home, your workplace, or more importantly, your vehicle. If you're a concealed carrier and you just want to better understand your rights, make sure to hit that like button, subscribe for weekly videos on Second Amendment law here in the state of North Carolina and nationally. So the first thing we're going to talk about is, what do North Carolina self-defense immunity laws actually say? Now, I'm an attorney here in North Carolina. I practice all sorts of law, but my interest is really in self-defense law and understanding how this stuff works. So in 2011, the General Assembly rewrote North Carolina's self-defense laws. Two key statutes were introduced: General Statute 14-51.2, and that statute covers the use of force in your home, your workplace, or your vehicle. Those three places are sort of sacred per that statute. And then there's General Statute 14-51.3, and that covers the defense of yourself or others anywhere else. So Point 2 covers the three sacred places: home, workplace, and vehicle. Point 3 covers all other places. So the statutes read like this: a person who uses force as permitted is justified and is immune from civil or criminal liability. You're immune. So really, here's the big question: does immunity mean you can't be charged? Or is it just another way of saying that you have an affirmative defense to present at trial? And an affirmative defense really means that they can charge you, but you can say, hey, I had a really good reason to do so, and this is why I cannot be convicted. Now, let's talk about justification versus immunity. What's the legal difference? If something is justified, typically what that means is that you have a defense, like, for example, self-defense. You present that defense at trial. If the jury believes you, you're not guilty. For example, self-defense, you have to use self-defense if you fear for your life. You only can use as much force as is reasonably necessary. But immunity is a lot stronger than self-defense. Immunity is a lot stronger than justification. Immunity, in theory, says that you will not be prosecuted at all. And some states will allow for a pretrial hearing to decide that very question. Now, North Carolina law doesn't give really quite clear procedures for how this immunity works, but it does seem to provide more than just a trial defense. Now, another statute touches on this idea of justification and immunity. General Statute 15A-954A9 states that on the motion of the defendant, the court must dismiss charges if the defendant has been granted immunity by law from prosecution. So the court has to do it. There's no question of whether, maybe the court will not or can they? They must if you have immunity. Now let's look at how other states handle the self-defense idea. Very famously, there's Florida, where their laws say that if you are immune from criminal prosecution, which includes being arrested, being charged, having a mugshot taken, Florida courts say that this is not a trial defense. It's a true immunity. So pre-trial, you can raise it. So they can start indicting you, they can start all this stuff, and you can say, hey, look, I'm immune. The law says here, you cannot charge me. Now, other states like Colorado, a little bit more stricter in terms of going after people, or lenient, depending on how you look at it. In Colorado, a judge will rule on immunity before trial if you used force inside your home. Can you believe that? Now, other states like Alabama will apply immunity to all claims of self-defense, not just if you're standing your ground. So anytime you say that, oh, I had to use self-defense, you're immune. Now, there are some nuances to this, but these states give us clues, and courts generally have agreed that immunity means that the charges should be dropped before trial if you qualify. So let's come back to North Carolina. Here's the $1,000,000 question for North Carolinians. Can you ask a judge to dismiss your charges before a jury ever hears your case when it comes to self-defense? Well, there's no really clear case law on this, but based on how the statute is written and how other states interpret similar language, you could have a very strong argument. What you do really is you file a motion, and a motion is pretty much a piece of paper you file with a request of wanting to do something. You'd file the motion, you'd argue that under General Statute 1451.2, that's the one dealing with your home, your workplace, and your vehicle, or point 3, everywhere else. You combine that with what we just talked about, 15A-954A9, and I just recently talked about that. So that one was the one that said on the motion of the defendant, so you file a motion telling the judge to dismiss it, or telling the court to dismiss it. So you combine those two statutes and you use them as your basis to seek a dismissal before charges are brought against you. Now, usually when you want to do things, there is a legal standard to do things. For example, if you are to be found guilty of a criminal offense, the legal standards is beyond a reasonable doubt. Any doubt that a reasonable person could have, not a doubt that an unreasonable or crazy person could have, simply put. So, what is the legal standard for these immunity hearings? Well, in most states with pretrial immunity, the defendant bears the burden. That's you. So if you claim you use self-defense, if you want immunity from prosecution, you bear the burden of proving that you lawfully used that force by a preponderance of the evidence. And the preponderance of the evidence is a lot lesser than beyond a reasonable doubt. Now, if the state usually are prosecuting you and they want to show that you did something, it's beyond a reasonable doubt. But if you want to show that you are immune from prosecution and that you used self-defense in the right way, your standard to meet is the preponderance of the evidence. All of the evidence viewed by the court means that you don't have to prove it beyond a reasonable doubt. You just have to prove that it's more likely than not that you acted in self-defense. Really, what this is a 51% chance, or 51% when the court looks at all of the evidence, a 51% chance or a 51% proof of the evidence that you used self-defense or that you acted in self-defense. Now, certain states like Florida, Georgia, Alabama use this standard. As you would imagine, these are states that are usually very pro-defense. It's a preponderance of evidence. So you, looking at all the evidence, you just have to prove a 51% chance that, yes, I did use self-defense because I feared for my life or something else. Other states like Kansas and Kentucky, you only need to show probable cause against the defendant. So the state only needs to show that there's probable cause that you didn't use self-defense. So that's a lot less lower opportunity for the state to prosecute you in those states versus in states like Florida, Georgia, and Alabama. Now, in North Carolina, it's very interesting because North Carolina, in some ways, swings when it comes to a lot of things, not just politically. So the states and the courts in the state could go either way until a case that comes along and settles this question. It could go either way. But ultimately, if a judge agrees that the immunity clause applies, the charges should be dropped. That's how it goes. Now, what happens at an immunity hearing? You decide that you want immunity, you believe that you use self-defense correctly, and you want immunity from prosecution. It differs on how these hearings happen. In Florida and Colorado, the court holds an evidentiary hearing. Witnesses come forward, they testify, and then the judge decides who's credible, what evidence is credible, and takes that into account. In states like South Carolina, the court can dismiss a charge against you without hearing if the written evidence clearly shows that you acted in self-defense. So that could be from police reports, that could be from video cameras. If it shows that you acted in self-defense, for example, if you're sitting in your vehicle and someone's jumped on the window trying to break it down with an axe or something, and you shoot them, that would be one instance. Another state, Kansas, requires the rules of evidence, and that's a whole different basket case that we're going to go into later someday. The judge interprets everything in the state's favor. That's really scary. Okay. Now, in states like North Carolina, a judge will likely take testimony, the judge will review video, witness statements, and then rule on your claim of immunity before trial, if that process is accepted by the courts. Now, so you've filed a motion seeking immunity. What happens if you lose at the immunity hearing? If you lose the immunity motion, it doesn't mean you're out of luck. You can still argue self-defense if it goes to trial. And other jurors are more likely to take your side than the court is going to. Once it goes to trial, you no longer have the burden to prove anything. Now it's the state that has to go into their bags and show that you didn't deserve to be in your home, you didn't deserve to be in your vehicle, you didn't deserve to be at work, you didn't deserve to use self-defense. And so the odds are now stacked against the state. So think of it as two chances. You get one chance before trial, and that's immunity, and then you get another chance during trial, and that's your justification. Immunity gives you an early opportunity to walk away without an arrest record. Finally, North Carolina self-defense laws are very powerful, but they're a little vague. Until courts define exactly how they work, it's essential that people who claim it understand their rights and that they stay ahead of the legal curve. So, to recap, there are two options. The first option is immunity, which is pre-trial, where you can say, I should not be prosecuted. Second option is justification if they do decide that they're going to move forward with trial if you do not fall under some protection of a state statute. At that point, you can argue justification